is allowed to be made and recorded. Blah, 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 blah.
What is the blah, blah, blah part?
And recorded. But not to be considered while a motion to adjourn is pending, or even after it has been voted to adjourn and before the chair has declared the assembly adjourned. The motion to reconsider that is made at such a time normally must wait to be called up at a later meeting unless it is made before the vote to adjourn is voted on and that motion is withdrawn or voted down. If the reconsideration is moved after it's been voted to adjourn and it appears to require immediate attention, however, the chair should retake the vote on that motion to adjourn.
I see no relevance because there is no motion to reconsider. There was no motion made at that meeting to reconsider after the motion to adjourn or recess. That's talking about if someone is in the process of stopping the meeting and you vote to or move to reconsider the issue.
Well, if I understand correctly, there's like a time limit. Unless you're adjourning to the next day or later that day, then anything that's not been taken care of needs to be brought up again more or less from the beginning.
You may be able to find a rule that does that, but what you just read there, I do not believe does that.
Mr. Cano?
Well, I'm no parliamentarian by expert of Robert's Rules of Order, is why I like this right here, but if you look at Rule 30, 35, I don't even understand the numbers at times. Page 228 talks about further rules and explanations. It states, when the adjournment closes the session and an assembly having its next regular business session within a quarterly time interval and having no members whose terms of membership expire before the next regular session, for example, in ordinary clubs and societies that hold frequent regular meetings, the complete order of business is followed at the next regular session. If a question was pending at the time of adjournment, it is taken up as the first item under unfinished business or under special orders, resuming the question at exactly where it was previously interrupted. And I think that's what we're trying to do is take it up where it was interrupted, and that was, we had a vote, it was approved to sign a number and read, and there was a move to adjourn and second, and we were gone.
Mr. Weaver?
That would be my understanding of what occurred, and that means that we're to the point of assigning a number.
Okay. We have a motion on the table to postpone this.
Excuse me, we have a motion to approve the reading.
Yeah. The motion to approve the readings supersedes the motion to postpone.
I move to lay aside temporarily the question on the table until such time as we have discussed the procedure for resolutions.
I'll second that.
Okay, it's a vote. Okay. We'll take a roll call vote. Restate your motion, please.
I move to lay aside temporarily the question until such time as we have discussed the procedure for resolutions.
And Mr. Raphael seconded.
Discussion.
Okay.
Discussion on the vote.
Ms. Balance?
Do we have discussion?
No.
It's a superseding motion. I don't think.
Vote was no.
Yes.
You're voting on your own
We're
motion.
backing up, right? Aren't we doing this one and then the first one?
We do this one, and if it passes, then that will move it. If it doesn't pass, we're back to assigning the number.
What was Ms. Balance's vote?
No.
Yes.
I thought you said no the first time.
Mr. Berry?
No.
Mr. DeVito?
No.
Dr. Kirkpatrick?
Yes.
Mr. Pownell?
No.
Mr. Parker?
Yes.
It's even. 3 yeses, 3 noes.
Okay. So it's up to me to,
Well, you can move on to the initial
Yeah.
motion.
okay,
Can you vote?
I can't vote. I'm going to
It
vote.
fails.
So it goes back to the original motion of putting, it's not even a motion, it's an action. Assigning a number and reading it.
Rock and roll.
Mr. Pownell moved to, okay. Do you want a voice vote on that?
Yes,
Or
ma'am. We'll have to
roll
have
call?
one on it. Let's do it. Roll
What motion? There wasn't a motion.
There's no motion.
call. Okay, well, that's true, yeah.
Yeah.
Just
Just
an
sign a
action.
number and read it.
All,
That's
It was,
what I
yeah,
understand.
it was voted on last time to sign the number and read it. So that was the action taken. Yes, sir.
if I understood what I said myself, it was not to make a motion. It was where we normally say I make a motion to open discussion on item 1, is that I stated that item 1 needs to be taken up where it was left off at the last meeting at adjournment.
That was adding the number and reading it.
So
Okay. Then we add a number and read it.
Resolution 587. Whereas Eureka Springs, Arkansas recognizes the need to provide or improve public access for the observation of Arkansas wildlife, and whereas the city wishes to apply for wildlife observation trails grant funds through the cooperative program of the Arkansas Game and Fish Commission and the Arkansas Department of Parks and Tourism, and whereas the mayor and the city council understand that if granted funds for development, they must provide land by lease or ownership by other means on which to develop the facilities, and whereas Eureka Springs, Arkansas will sign a contract agreeing to provide the necessary resources to maintain this park and facilities for a period of 10 years. Now therefore be it resolved, City Council of Eureka Springs, Arkansas hereby authorizes the mayor to submit an application for grant funding to the Arkansas Department of Parks and Tourism.
Thank you, ma'am.
what was the number?
587.
587.
Next item on the agenda is aerial photography contribution. Motion to discuss.
So moved.
Second.
Second? All right. Second. All right, I believe at the last council meeting, I gave you a bit of information about the Carroll County Tax Assessor's Office wanting to enter a program with a company called Sanborn, in which they offered the aerial pictography or aerial photographs of 6-inch and 12-inch imagery. Had recently been contacted by Ms. Joanne Harris, who is the assessor, who stated she attended a meeting in the corridor, and during that meeting, I believe it was Springdale, and correct me if I'm wrong, Ms. Harris, has pulled out of the agreement to do the 6-inch. They are now talking about going back to the original company that presented a program called Pictometry. A gentleman named Trent Evans gave that demonstration, and it was quite impressive. And they offer 4-inch photography and 3D photos of whatever the case may be. And I think the prices are comparable. If it's the wish of the council, I would be more than glad to invite Mr. Evans over here for a demonstration or a discussion, and he can tell you more about it than I can, but it was impressive. Yes, sir.
I understand the commitment still needs to be made, and this is our last one more meeting in November. We're faced with...
I'm not sure now that the commitment needs to be made
Okay.
if we don't go with Sanborn.
I just feel that based on the information that I've gotten from the concerns that the MAP money that Planning Commission is looking for if we get what we're going to be paying for, is much more needed than aerial photography of Eureka Springs. But if people are willing to come forward and make a presentation, as long as we aren't stuck with a commitment, I don't have any problem with that.
We're under no obligation to commit to either one of these two entities. This is just informational at this point. And Ms. Harris seems to think that it would behoove Carroll County and any other municipalities that want to join in, or other county entities that want to join in, to consider the first offer through the quality of the product and the availability of the product and the variety of the product, actually. And this came from her. Now, if you feel so inclined, you can contact Ms. Harris at the assessor's office, and she can give you more details than I can. This was just a quick note to us, and I'll pass it on to y'all. Yes, sir.
Just for information purposes, and I'm not anywhere close to pretending to be a lawyer, but based on the real estate needs, the title company needs, the things that are needed within this town to be able to properly identify and zoning and selling and buying and adapting property, building, the money, again, if you're looking at two different maps, one being aerial photography, which cannot be used for any type of translation into ordinances, zoning, or otherwise, versus a good zoning map, I think that one outweighs the other one tenfold.
Any further? Okay. What is the wish of the council on this demonstration from Mr. Evans? Yes, sir.
I think we should have the demonstration. When I had talked to the mayor of Berryville, he was very impressed and said that they're going to go ahead with it, mainly because of the location and the use in water and sewer, fire hydrants, manholes, things like that, along with streets. And while our zoning map may be to scale, it's not going to give us direct information on streets, a lot of streets and existing streets that are open or not open. It's going to give us the map that we have. I doubt that we're going to be able to fund both of them, but it'd be interesting to see his demonstration and see what kind of contribution it would cost us to be involved. And
Okay.
I think we'd be short-sighted not to at least listen to him.
Okay. So is that a consensus amongst the council to go ahead and invite Mr. Trent over here for a demonstration? Okay. I'll do so and let you know by the next meeting. Okay. No further questions? I think everybody was shaking their head, yeah. It's just an update. Okay, number 3 on unfinished business is dog control update. Mr. Pownell, move to discuss.
Well, I've gotten a lot of...
Move to discuss.
Second.
I'm sorry. I was just listening
Okay.
to him.
All right, go ahead.
A lot of input. The changes have been recommended through the workshops. The inputs that have been gotten during this process have been forwarded to the city attorney. Excuse me. Two major things that were of concern that was kind of slowing this down, and since there are some out there in TV land that think I like to drag my feet, I was trying to make sure I had all the facts first. First of all, one of the concerns in discussions with the animal control officer, as I believe, if I remember correctly, he stated he's under contract, and I want people to understand he's not a city employee. He's under contract for 10 hours a week. He pays for his own gas, uses his own vehicle, buys his own animal traps, and has written quite a few tickets. As a matter of fact, I went to the district court office, and this is what I've been waiting for, because he was to the point of, if my writing tickets isn't doing any good, then what's the use of me writing tickets? And since we now have that information, I can pass along to the public, along with the changes that they've asked for. From January the 1st until today, there were 34 tickets issued. The number one concern is the one that's kind of started the whole thing with the Lulu incident, which is still pending. He pled not guilty, and I guess they're going through the normal whatever's in legal discovery, et cetera, et cetera. 17 basically forfeited their bond without even coming to court. 3 pled guilty and paid the fine. 8 are still pending. 6 nothing's been done on because they were recent, and 8 pled not guilty. So those are the ones that are currently. So there is action being taken, as Mr. Weaver informed us the last 2 times this was questioned. It does take a while to get through the process. My concern is, number one, talking with the people that were actively involved in the workshops. We've finished up pretty much being able to do the changes, and I've got a few more to forward to the city attorney. Is that there's some concern that things were kind of just falling through the cracks, and apparently that's normal under judicial process. The ticket for the vicious dog ordinance violation was April 4th, 2011. Actually, tomorrow is the next court date. So that and court dates have been set for the other ones that have pled not guilty, and those have been set for December. So that being said, I applaud Mr. Evans's job that he's done. I believe that the next thing, based on the recommendations that have been given to me as chair of this committee, is I have not seen the contract that the police department has with the animal control officer, but he's working probably 2/3 more time than not. What the contract calls for is that the police department needs to look at upping the hours in that contract, because if from what I've seen and heard, there are still issues, but if we can still put some meat into the, or I would say bite into the ordinance, but with the changes we recommended, some of these are going to be pretty serious, and I think that the proposed changes will help satisfy a lot of the problems, as long as we're able to have the animal control officer out there enforcing it. And to do that, the police department's going to have to look at putting some more money into their independent contractor contract for the animal control officer. And that's all I have at this point until I hear something back from the city attorney.
Thank you, sir. Any discussion? Any further? Okay, if not, move on to number 4. Vacation to Palo Pinto, postponed until November the 3rd. Motion to discuss? Yeah, well, we're going through the process, but she wants it postponed temporarily and actually removed to be brought back at whenever she gets ready. So,
Removed completely?
taken off the agenda, but to be
Okay.
brought back at a given time. Mr. Pino?
I make a motion to remove it from the agenda until the parties bring it back to the table.
Second.
Made and seconded. Any further discussion on it? All in favor, say aye.
Aye.
Any opposed? All right, motion carried. All right. Number 5 is non-conforming off-premise sign, postponed till corrected. I think we need to vote on that one. It's postponed. Number 6, postponed last time until today to update the alcohol beverage CPC tax right to collect.
Until November.
November 3rd.
November 3rd. Okay, I'm sorry. Yeah, I was looking at the wrong one. Number 7 is still open. Be the second reading of ordinance 2143. Codify parks, 1/4 cent tax. Motion to discuss.
So moved.
Discuss second reading.
Second.
Made and seconded. All right. Discussion. Mr. DeVito.
I would move to suspend the rules and place ordinance number 2143 on its second reading by title only.
Second.
All in favor?
Aye.
Roll call. I'm sorry. Roll call, Sonia.
Yeah.
It's confusing.
Pownell,
Yes.
Dr. Kirkpatrick,
Yes.
Ms. Balance,
Yes.
Mr. Raphael,
Yes.
Mr. DeVito,
Yes.
Mr. Berry.
Yes.
Ordinance 2143, ordinance confirming the adoption of the initiative ordinance approved by the electorate of the city of Eureka Springs on November 7th, 2006, regarding amending ordinance number 1906 and assigning it a number.
Yes, sir.
I'd like to, I move to approve the reading of, the second reading of ordinance number 2143.
Second.
All, we need a voice vote on this. All in favor, say aye.
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 Any opposed? All right. Second one's written. All right. Next on the agenda is number 8, Mr. Ray Dodson's franchise application proposed till November the 3rd by his request. Apparently he has some family issues he's trying to take care of. So,
Question.
Yes.
Point of question. Do we actually have a application in City Hall?
Ms. Clerk, can I
He's going to
answer?
submit a brand new one.
I think you started brand new. Yeah.
In that case, I'd make a motion to remove this from the agenda until such time there's an appropriate application received.
Second.
I think that last time I spoke with Mr. Dodson, he was still going with the one he had, but he was going to possibly make corrections to it. I may be late on my information, but that was not what I understood from my last conversation with Mr. Dodson. He was still relying on one that he has before the council.
Mr. DeVito.
An application would come to us regardless of whether or not he's amending the original application or making a new application.
Okay. Motion been made and seconded to postpone and remove, actually, until all the paperwork has been taken care of and resubmitted to the council. Mr. Berry?
If he is under the assumption that the paperwork's already done, then does the application just need to be presented to us?
Go
My
ahead.
understanding is that when he's ready for the application to be presented, council has 30 days. It needs to be heard within 30 days.
Mr. Penna?
Therefore, the clarification of do we or do we not have a application in City Hall that's valid.
Not that I'm aware.
I think Mr. Dodson has the opposite opinion last I heard from him, that he does have a valid application before the council. Filed with the
What
Mr. Berry?
what makes it not a valid application?
There is material that was in the 2010 file with a map that overlaps existing
Thank you, Nate.
routes and is not improved or franchise. That's one that I have seen. And my impression is from our last discussion, we had 2 good discussions this week, that he was going to modify that. So, my understanding, resulting from the conversation, the 2 conversations he and I had on the phone, that he's going to bring an application for council's review.
Okay. Motion to remove and seconded until paperwork submitted. All in favor, say aye. Any opposed? Motion carried. All right. That is all we have under unfinished business. New business. First item on the agenda is procedure for passing resolutions.
Move to discuss item 1, procedures for passing resolutions.
Second. Made and seconded. Discussion's open. Mr. Parnell.
Since I'm the one that seemed to stir this can of worms, my concern has been and always has been and always will be is that unfortunately we made an error in changing procedures, but at the same time there's no record that shows that we changed them officially, that they'd be done consistently, and hopefully this will do it consistently. Is I would like us to admit that everyone is human. We've sat here and read some resolutions. I've heard some resolutions read in the past that had a number assigned and were read, that probably if we had a different procedure in place, a different, some grammatical and some even maybe some contractual or concerns with the wording would have been resolved. That's one of the reasons I'd like to see us have a two-step procedure, and that being a motion to assign a number and read for discussion a resolution, and the second part, and for some reason there's some indication from what I've gotten back on this issue, is that we're talking about a different meeting. Its second step right after that one is to move to approve as read or as amended, and will be done in the same meeting under the same agenda item.
Mr. Vina?
If we move to discuss a resolution, we should be able to get all of our concerns out of the way and then proceed with the traditional vote to read the assign a number and read the resolution, which is a vote of passage.
Anybody else? Mr. Park?
Well, I like the idea of reading the resolution and discussing it. And then somebody might have some information that you don't have, and then you could make an intelligent vote on the resolution. Seems a two-part thing would be makes much more sense.
Mr. Vina?
Well, we have the resolution before us that we would be discussing. I hesitate to go to the procedure of passing an ordinance to a resolution because they're two different items. Resolution is much more benign than an ordinance. So a motion to discuss, the resolution sits before us. If there's any questions we have, they should be brought out during the discussion phase, and then the second part of it is then to vote on the reading of the resolution, which in effect passes it.
Any further? Mr. Pownell, was that a motion that you made, sir?
I'll make a motion to have a two-step process of passing resolutions. One, to read and discuss the resolution. Second part, to assign a number and approve as read or amended.
Second.
Made and seconded. This can be just a regular voice vote.
It probably should be a roll call vote
Right.
because of your decision to make ultimate decisions by roll call.
Ms. Balance?
Yes.
Mr. DeVito?
Yes.
Mr. Berry?
Yes.
Dr. Kirkpatrick?
Yes.
Mr. Raphael?
Yes.
Mr. Pownell?
Yes.
6-0.
6-0. Motion carried. All right. Number 2 on the agenda is discussion of Hospital Commission. Hospital. Mr. Pownell, Ms. Balance. Motion to
Move to
discuss.
discuss.
Second.
Made and seconded. Floor is open.
In doing some research, the question came up. I was looking through some old minutes of past meetings from years ago, and I think there's maybe been one hospital commission meeting televised to the public. There's also been resignations from the commission because there's been attempts not to publicize the meeting times and agenda, which led me to the state code, or the city code, which talks about the so far back, I can't believe we got through unfinished business that fast. Under City Code Chapter 2.68 Hospital Commission, Chapter 2.68.01, it's created. There is created a hospital commission of the city pursuant to the authority and provisions of Arkansas Code as annotated 14-264-102. That's the only direction that the local hospital commission has. There's been one or two reports over the last 3 or 4 months. There has been several presentations by the people currently operating the hospital. I checked into the files. There is an assignment and lease agreement, and I've forwarded this information, and I'm not trying to catch him short, but he's had little time to work on it, and I just want to bring it to the attention of the table in case somebody does have some other information. The state code states that the hospital commission can only lease the hospital to a not-for-profit or benevolent organization. The 9th of February 1995, the hospital commission, the city of Eureka Springs, and let's see who exactly signed this. I believe it was the commission and someone from, anyways, between the hospital commission and the Eureka Springs Hospital Commission, as I just read, under the Acts of Arkansas 1947, with Eureka Springs Community Healthcare Incorporated, an Arkansas nonprofit corporation which owns certain personal properties in connection with the facility. This lease was for 25 years, and the second point of concern is that it began the 10th day of February 1995, and it was to be at the sum of $5,000 a month paid on the first of each month and continuing until the termination of the agreement. At the end of each 5-month period, the lease was supposed to go up $1,000 a month, so that would mean on February 2000, the rent would go up to $6,000 a month. 2005 would go up to $7,000 a month. 2010 it would go up to $8,000, et cetera, et cetera. It also states that any capital improvements, maintenance expenses will be covered by this particular leasee, and that the city can contribute to equipment, which we have done in the past based on ordinances and resolutions that are on file in the records. And it also talks about assignment. This agreement may be assigned by the leasee to any affiliated entity, provided the assignee assumes and promises to perform all the obligations of the leasee hereunder. As used herein, affiliated entity shall mean any corporation which is controlled directly or indirectly by Washington Regional Medical System. Any other assignment shall require the advance written consent of leaseor, which consent shall not be unreasonably withheld. In the file, there was nothing that showed that this lease has either been terminated or that has been assigned to any of Washington Regional's other entities. But there's also been action taken by the hospital commission since this was written that turned the operation of the hospital over first to one company, and I do not believe that they are considered by corporate structure a not-for-profit, and secondly, it was then turned over to another, and I think a lot of that has been done with promises of a new hospital. My concern number one, and it's strictly a fact-finding at this point in time in coordination with the city attorney, is number one, is the lease still in effect, and if it is, where's the money gone? because the hospital commission is solely responsible for that. And then in accordance with state law, then they, if that's the case, they are to report through the audit system the use of that money, where it's at, in a separate fund, et cetera, et cetera. And lastly is that the concern of one of the commissioners who I talked to that had just been appointed after he served on planning commission said, well, don't bring anything up because right now we're getting money based on something about the hospice. So I'd just like a clarification on why we're in, if all this is still active, then part of the state audit report is probably correct, and we are missing hospital commission reporting. The second thing, if they aren't, then why do we even have a hospital commission? So if anybody has any, and this has been on the agenda long enough, I really thought I would have heard from some of the commissioners or people that probably have a little bit more wherewithal than I do as far as, but the only records on file in City Hall are what I just basically read is the lease agreement, and there are a couple letters between the two companies that are currently wrangling for control of the hospital, one turning it over to the other, and still I don't see any approval by this body, Washington Regional, or anybody else approving the assignment of the operation of the hospital. So I question the actions of the hospital commission whenever they first contracted out with Mr. Ortega's company out of New Orleans or Louisiana, wherever he was at, and I cannot think of LHC or whatever the name of his company was.
Any further? Okay. There's nothing else. We'll move on to number 3.
So is that considered, excuse me,
Go ahead.
is that considered finished or just?
There's no other discussion.
Okay.
You were addressing Mr. Weaver.
Thank you.
Mr. Weaver, you have any questions? Anything to say?
Other than the hospital commission has, for many, many years, maintained their own council, and I believe they still do. I believe that may be one of, maybe Lewis Epley. And these might be better questions that are referred to their attorney that they've used rather than to my office.
My understanding, there was supposed to one of the representatives was supposed to be here tonight. One of the commissioners was supposed to be. Apparently, that didn't happen.
Some people
Are there now? Okay. Mr. Pennell.
In response to that, the first sentence of the agreement says it's between the city of Eureka Springs, Arkansas. So I think that unfortunately does throw the city attorney into the fray, unless there's been something changed when this lease agreement was originally signed in 1995.
Okay. Mr. Balance.
Would Mr. Parnell like to postpone this discussion until next meeting, or would he
No.
like to dispose of it in some other way?
That's why I was asking is there what the process would be. I'd like to see an answer to the questions that I've
I
thrown
believe
out.
there is a hospital commission meeting next Monday night at the Methodist Church. It was supposed to have been this time, they changed it. This last Monday, but they changed it to next Monday night.
Has there been an agenda published?
I don't have it.